Well, good morning. Welcome back to the broadcast, Retirement Network. I'm Jeff Snyder. This is BRN AM for Tuesday, March 8th, 2022. And our top story today, U.S. retirement plan push amplified by a recent court decision. Well, joining me now to discuss this and a lot more, Austin Ramsey is a journalist with Bloomberg Law. Austin, great to see you. Thanks so much for joining us on the program this morning.
Good to see you too. Thanks so much for having me.
Yeah, and so today we're going to talk, we got a plethora of issues to talk about based on your writing. Let's kick things off with a look at Cal Savers. And the Supreme Court basically did not take a case from the district court level. What's it all mean?
Yeah, so Cal Savers is one of a handful of states that California is one of a handful of states that has passed these what we call auto IRA programs, automatic individual retirement account programs. These are essentially designs that allow states to mandate retirement savings. They're automatically enrolling participants that are employed by businesses that don't already offer some type of workplace retirement savings program. A tax lobbyist group in California sued Cal Savers, which is run by the Treasury Department there, saying that this is preempted by ERISA, the Employee Retirement Income, or the Employee Retirement Income Savings Act, which is a 1974 law which basically sets a federal mandate, federal minimum standards for workplace retirement savings. This tax lobbyist group was saying that, look, we already have a law in place here that sets these minimum standards. States like California, Illinois, Oregon, other states that have passed these programs, they can't go about setting new standards that are preempted by ERISA. The district court and the appellate court both said no. Because this is not a requirement on employers, it's only requiring that employers essentially just pass over a list of employees that they have to the state. Because there isn't an actual mandate that the employer do anything, it's not actually preempted by ERISA. The Supreme Court essentially greenlit these programs. And it's interesting because it sets up kind of two different methods of retirement savings in the United States now. You obviously have your workplace savings path that is sponsored by your employer. Your employer is a quote unquote fiduciary of that plan. And then these auto IRA programs where the state is the retirement savings sponsor. They take on that fiduciary responsibility. They hire, an investment manager to handle your money. So for the time being now, we have these two tracks, these two retirement savings tracks, and the Supreme Court has essentially said that that's okay.
Yeah, and let's be clear about the auto IRA programs are really designed for the 70 million plus people who don't have access to a workplace retirement plan, or at least didn't. Now, the Secure Act, I think, included PEPs, pooled employer plans, and we've seen the retirement plan providers like record keepers like a Fidelity and Voya and others create plans. But you're essentially right. It's two tracks, but this was set up as a way to help those 70 million people who don't have access to a plan.
That's absolutely right. Yeah. Congress has been trying Secure Act. They're working on other legislation now, trying to get individuals who don't have access to retirement savings at work to get access. They're trying to encourage employers to set up new plans. But look, it's a costly venture for an employer, especially a small business. Think of your mom and pop bagel shop on Main Street. It's an expensive proposition for them to set up a retirement plan. Obviously, pooled employer plans, multi-employer plans, these programs are intended to try and help cut down those savings, help make it a little bit easier for these small employers. But there's still a lot of barriers. And I think a lot of states have kind of gotten fed up with this. And what they've essentially said is, in lieu of a federal mandate, in lieu of the federal government saying, look, we're going to mandate that all employers provide some type of minimum retirement plan. These states are saying, well, we're going to do it, unless the employer or the employee opts out of participating in a plan, they're automatically going to start saving in states like California, Illinois, and Oregon once they get a job.
What about, okay, so you've got these 50 states plus territories, and what if they all come up with a plan? Is there any movement afoot? I mean, what does the industry, what do the regulators, the legislators take away from this? And I remember back in, I think during the Obama administration, a push to create a federal structure. And you said that that's kind of DOA, but what about a federal kind of a reporting structure so that there is parity? One of the challenges when you have different states is you have different sets of laws, different rollover rules, all sorts of different things that can make things difficult if you want to move your money between Oregon Saves, for example, and Cal Savers or a workplace retirement plan. Is there a chance that we could get some apparatus, some regulation that creates a little bit more structure there?
There's absolutely a chance. First of all, you're absolutely right, Jeffrey. Employers, big companies that operate in multiple states are telling me that this is a big problem. It's causing a lot of headaches because they have different standards according to all of the different states that they do business in. And you're right, back in under the Obama administration, there was an effort to create a MyRA program, which would essentially, not mandate retirement savings, but offer a very simple kind of treasury securities level investment to employers who wanted to participate, and it would be at no cost to those businesses. We saw a proposal in the kind of first iteration of the Build Back Better agenda under the Biden administration, which would have actually required retirement savings. It would have set up a very basic, like low-cost 401k program or IRA that employers could provide, and the cost would be offset by some tax deductions on those businesses. But unfortunately, obviously there's been a lot of pushback from Republicans on the Senate. And so that was pulled out of the Build Back Better plan. We have heard that it might still be floating around in Congress. We know, obviously, that Congress has a lot of interest in following up on the 2019 Secure Act with Secure Act 2.0. Interestingly enough, both advocates, proponents and critics of the state level programs are interested in providing a federal, mandate essentially for retirement savings, even though mandate can sometimes be a 4-letter word, because it would
you don't say
because it would alleviate those problems that you mentioned, which is that businesses just don't know how to operate in a system that is, so divided between different states and different programs.
Yeah, well, it sounds like this one is not over by a long shot, and this is part of what happens in a democracy where you have different points of view and you kind of work through them and try to come up with regulations and legislation that makes the most sense. Well, Austin, I need to take a very quick break. When we come back, insurers are straining with trying to adhere to new Department of Labor regulatory rules around rollovers. You're going to want to stay tuned right here on BRN AM. Imagine a new television network that will make you richer, healthier, and in control of your financial future. This network is for the policewoman in Nashville, Tennessee, the baker in Dubuque, Iowa, the teacher in Lexington, Kentucky. We want to make the idea of savings and retirement culturally relevant. But what do you see as a defining issue of the midterms, especially for the smaller businesses? I mean, they are the lifeblood of the American economy. Featuring exclusive interviews, current affairs, and docuseries. 33 years old, you retired early.
The philosophy is money only matters if it helps you live a life that you love.
But you got to start thinking about retirement as soon as you get in.
The Broadcast Retirement Network will drive very high engagement with premium partnerships. So this isn't retirement and savings for your parents or grandparents. This is for all Americans. And we're going to change the way you think about money. Welcome to the next frontier of retirement and savings. This is BRN, the Broadcast Retirement Network.
Are you over 50? Would you like to get up to 33% more income in retirement? Then call now for this free book, Annuity Do's and Don'ts for Baby Boomers. This free book reveals little-known secrets about annuity strategies that will help you make the right choices before buying an annuity. Call right now for your free book, and as a bonus, we'll also throw in a free annuity rate report, both absolutely free for calling Annuity General today.
Call 800-504-8194.
Welcome back. We're talking this morning to Austin Ramsey. He's a journalist with Bloomberg Law. Austin, thanks so much for sticking with us this morning.
Absolutely.
Haven't chased you off yet. That's great. Really appreciate that. All right, let's talk about potentially some new fiduciary standards. As we said in the first segment, having new rules and regulations, especially 50 different versions, that creates a challenge for any business, anyone to figure out how to adhere to. Retirement is a highly regulated business for a lot of obvious reasons, fees, investment advice, etc. But what's the latest here about these new Department of Labor regs, and what does it mean for insurers?
Right. So last month, the U.S. Department of Labor began to enforce a new exemption for fiduciary advice. This is really important to insurers, life insurers, who are providing annuity products, especially to 401k, defined contribution investors who are interested in rolling their retirements over into a lifetime income investment option. The exemption that the Department of Labor came out with here, actually this originated under the Trump administration, but last year, under the Biden administration, they interpreted the Trump administration's rule to mean that first-time or one-time investment advice can sometimes meet the very high standard of fiduciary advice if it's intended to be part of an ongoing series of advice. Sometimes that's according to the type of annuity product that you're purchasing. Now, that's a big deal to life insurance providers because, often they're relying on independent contractors or independent agents who don't want to be held to that really tough, that really high fiduciary standard for a number of reasons. It's very expensive. It also means that both the insurance agent, and the company that the insurance agent is providing through are held to some really, really strict disclosure requirements that the U.S. Department of Labor now is enforcing. And so what's interesting about it, though, is that a lot of the lawyers that I've spoken to are saying that, look, although there's a lot of fear around these really tough fiduciary standards under the Department of Labor's new interpretations, some types of annuities may not qualify. But because there's so much fear, because there's so much, uncertainty surrounding these new interpretations, most life insurers seem to be operating under a new standard whereby just about all of the rollover advice that they provide is considered fiduciary advice.
And let's be clear. I mean, a lot of those advisors, people that you're talking about providing advice, they get some kind of trailing commission. They get paid. Typically, they're paid on a commission. And by the way, that's not a bad thing. As long as it's disclosed, that seems that's a perfectly fine way of people conducting themselves. What does this new regulation mean in terms of conducting business? Does it drive some of these people who are commission based, who are maybe work for smaller firms, out of the business? Oftentimes, regulation is tough to adhere to when you're a smaller enterprise. A large enterprise, they have the resources, the dollars to implement major changes like this.
what the regulation actually does is it provides an exemption to these insurance agents and insurance companies to allow them to collect a commission on the advice that they provide. Just to kind of cover our bases here, fiduciary advice, base level, says that you cannot collect any type of additional income. You can charge a base fee for the advice that you provide, but you can't collect any kind of additional income based on the type of advice that you're providing. In other words, you can't collect a commission because you sold a certain insurance product. This exemption says that although you are a fiduciary, you can still collect a commission, but it tacks on all of these additional requirements in order to comply. Now, I think a lot of insurers are saying, look, we can stomach this, but they don't want to have to stomach it. And like I said, what's really interesting is that because there's so much uncertainty about this, and because the Department of Labor really hasn't said anything about it since they offered up their latest interpretation, insurers are just weighing on the safe side, and they're starting to decide that, look, just about anything and everything that they provide is going to be fiduciary advice. Now, why that matters to you, why that matters to the customer, the client, is that fiduciary advice is considered by some standards more expensive. Under some experts believe that this could lead to a type of, closing off of the marketplace where, smaller, clientele who don't have as large of an investment lineup to offer, that they won't have access to the same advice as individuals who have more assets in the bank.
Yeah, and I was going to ask you about, what's the net takeaway for the consumer? One, you should always be vigilant, I would think, about what products you're getting yourself into. Even if you have a great relationship with your financial advisor, make sure you understand the basics about the investment, the fee, the structure, the type of investment it is. But also, this, as I was saying earlier, regulation is expensive and could change the advice industry completely for those that need advice the most.
That's right. And Jeffrey, I think another important piece of advice for these retirees or individuals who are nearing retirement is ask the individual that you're talking to. Ask them, are you held to a fiduciary standard? Are you acting as a fiduciary when you provide this advice? If they are, know that they may be relying on this kind of exemption. And like you said, that's not necessarily a bad thing, but fiduciary advice is considered the highest level of advice. It doesn't mean that other types of advice aren't good, but that is the highest standard that the U.S. Department of Labor is regulating. And so, it doesn't hurt to ask. I would certainly recommend. Yeah.
Yeah, it does not. And people should be looking at the Form ADV. In advance, when they're working with a financial advisor, they should be checking that regularly. I know that it gets provided to people, I think, as well electronically, but it's something you want to definitely think about. Well, Austin, we're going to have to leave it there. Thanks so much for joining us, and we look forward to having you back on the program again very soon.
Absolutely. Always a pleasure.
That wraps up this episode of BRN AM. Have a topic of interest, someone you think we should talk to, drop us a line. And don't forget, for all the latest in lifestyle, wellness, finance, tech, so much more, all in one place, check out today's edition of our daily newsletter, The Morning Pulse. Want to see our latest content? Search our archives. Well, of course, you can check our website, www.broadcastretirementnetwork.com, and our streaming partners like Amazon, Roku, and over 100 more. We're back again tomorrow for another edition of BRN AM. Until then, I'm Joe Snyder. Stay safe, keep on saving, and don't forget, roll with the changes. Now is your opportunity to co-create content around any topic on the first lifestyle and wellness network. Reach a global audience through our platform and co-own exclusive branded content. All of our programs are available on demand and also as audio-only podcasts, so you can take us on the go. Broadcast Retirement Network, available anytime, anywhere, and on any device.
Are you being audited and do you owe the IRS $10,000 or more in back taxes? Is the IRS threatening to take more of your money? Don't fight the IRS alone. The Tax Doctor is here to help you negotiate your tax bill and reduce your stress. The IRS can freeze your assets and seize your bank accounts, but you can stop these IRS actions. The Tax Doctor will work with you using our years of experience to represent your case to help you get the best resolution under the IRS guidelines. Help is here to deal with the IRS to reduce your stress. We've handled thousands of cases, so we know what we're doing. If you owe $10,000 or more in back taxes, do not call the IRS alone. Call a Tax Doctor now for a tax emergency analysis.
Call 800-224-6439.